So we cannot think that Operação Acolhida, welcome operation in Brazil, that Brazil government participated, the United States financing of the UN agency, was not the interest of the United States to have resettlements in Brazil, well-ordered migration, and keep Venezuelans in Brazil instead of going north. So it was military scholars mitigated by this idea of securitization and management of borders. It is the erosion as well of the moral authority. It's the same power that proclaims universal rights, engaged in sanctions, occupation, and externalization of borders policies that deny those very rights. Thus, this Western humanitarian order operates in a state of normative contradiction. It proclaims universality, but it practices exclusion. So, let's not forget about what Western intervention in geopolitical displacement. So, it's impossible to discuss displacement today without acknowledging a causal link between Western interventionism and the production of migrant flows. Consider Iraq, Libya, Syria, free states whose social fabrics were destroyed under the banner of democracy promotion or humanitarian intervention. This war of the early 2000s generated tens of millions of refugees and internally displaced persons while leaving behind institutional vacuum that perpetuates violence up to these days. Haiti offers a different but equally equivalent case. The UN mission after the coup against Bertrand Steed, the supposed socialist that the US held, the MINUSTA established in 2004 and led militarily by Western powers, Brazil included, institutionalized a regime of international tutelage that eroded local sovereignty while failing to build suitable institutions. The result was a dependency, corruption, and a mass exodus that continues up to these days. In Venezuela, subject sweeping unilateral sanctions since 2015, of course, there are internal problems illustrate another mechanism of displacement. Economic strangulation as a tool of regime change. Sanctions have crippled public service and forced millions to flee, primarily to neighboring countries that receive little international support. Across the case, you see a pattern of what was termed imperialism, humanitarianism, a regime that generates displacement through coercive policy and then seeks to contain it through border militarization and externalization. This is a double movement of contemporary humanitarianism. It produced displacement through interventions, then into management, displacement through containment. The ethical contradictions could not be stronger. So there is this failure of this legal universality as well. At the normative level, the 1501 Refugee Convention is a remarkable historical achievement, but it has reached its limits. It was designed to post-war Europe, but for individual persecution in the form of divided by ideological wrongs. It does not recognize a structural form of violence, such as environmental collapse, sanctions, transnational conflict, that do not within traditional legal categories that is protected by the Refugee Convention of 51. So by that we can say that the system itself is very limited to a very specific group of forced migrants that is very minor compared to the other groups. So as a result, the regime became a technology of exclusion through legalism, the insistence on individualized persecution criteria has left millions of displaced persons, especially in Africa, Asia, and Latin America, outside the scope of the protection. So now where we are, the tendency of securitization and containment through international organizations and through North comes from the North. So parallel to the decline of humanitarian universalism, we observe the rise of a global containment architecture. The European Union migration pact with Turkey, Libya, and Tunisia, and the US-Mexico agreement under the so-called Safe Third Country framework, and the proliferation of detention centers in North America and Central America all reflect a single trend, the externalization of borders. Humanitarian language is used to legitimize this practice. Saving lives at seas, order migration has become synonymous with preventing arrivals. The NGOs rescue migrants in the Mediterranean are criminalized, while the European Union finances militias in Libya to intercept boats. The regime represents a profound inversion of the humanitarian principle. The protection of life has been replaced by the management of mobility. From a legal perspective, the non-refoulement principle, the cornerstone of refugee law, is now systematically violated through pushback policies, interdictions, indirect expulsions, the terrorist policy. From a moral perspective, this reflects the collapse of solidarity as a governing norm of the international order. So, where we can go? Yet the Global South has not remained passive. From a perspective of what it is and should be considered as refugees, since 1969, the Organization African Union Convention expanded the definition of refugee to include people fleeing aggressions, occupation, and public disorder. The same way, before the Geneva Declaration of Latin America went further, embracing victims of generalized violence, systematic human rights violation, as someone who should receive the status of refugee. Brazil recognized more than 100,000 Venezuelans under this concept of generalized violation of human rights in the region. As prima facie, instead of individualized persecution, because it's a region that provokes forced migration. So in other words, the South has already produced the normative seeds of a post-hegemonic humanitarianism. The challenge now is to institutionalize them globally, because the real force movement, humanitarian agents that will protect all, not a few. So the idea that I present is that the BRICS can do a reconfiguration of the global governance. So against the backdrop of Christ, the BRICS So against the backdrop of Christ, the BRICS emerged as both a symptom and as a response. Initially, it was an economic revolution. The group has evolved into a political project of normative pluralism by challenging the monopoly of the Bretton Woods institutions and proposing new mechanisms of financing, such as the New Development Bank and the contingency reserve arrangements. The BRICS have laid groundwork for what could become a architecture of global humanitarian governance. This paper advanced two concrete institutional proposals. A BRICS humanitarian fund, maybe to convince, that should be anchored with the New Development Bank and neutral to finance response in crisis connected by traditional donors and by the traditional conception of refugee established by the UNHCR. The fund should support those states in the global south that currently bear the heaviest humanitarian burdens. Because we know that the global south is the area that concentrates the massive flow of forced migrants. It's not the global norm, so we need to start to gravitate around problems of the global south. BRICS agents for forced migration, an autonomous but complementary body to the UNHCR with a broader mandate to protect people displaced by environmental degradation, sanctions, and systemic state collapse. Together, this mechanism would reduce dependence of North financing, decolonize the bureaucratic structure of humanitarian governance, and extend the legal horizon of protection. Beyond institutions, what's at stake here is a paradigm shift from humanitarianism rooted in charity and control to one grounded more on solidarity and core responsibility. So, can we say that we go toward a more positive, more like humanitarianism? What would such a transformation entail? So, it requires the democratization of global bureaucracies, as the BRICS insists on the new global governance to participate, to be more part of the group that direct, for instance, our humanitarian agents. Today, leadership across agents is overwhelming question. Parity in representation is not a matter of symbolism, it's a matter of legitimacy. Second, it calls for a redefinition of global norms to reflect the realities of multipolarity. The South cannot merely participate in governance, it must help redefine its ethic and epistemological foundation. And third, it demands a reconstruction of solidarity as a governing principle. Humanitarianism cannot continue to operate as a model for intervention and exclusion. It must become a political practice of sharing responsibility, recognized by most displaced population already reside in the South. And that genuine protection begins with redistributing not only resource but also authority. So to conclude, a call for refounding protection and humanitarianism in the world. So the current humanitarian order faces not a crisis of management, but a crisis of imagination. It breaks with the demographic wave, institutional innovation, and historical experience with displacement, have the potential to refound the humanitarian system on plural, equitable, and sustainable grounds. In the 20th century, we belong to humanitarianism of the North. 21st century must belong to humanitarianism of humanity, inclusive, plural, and decolonized. Let me close with one line that captures the spirit of the transformation. To reimagine humanitarianism in the 21st century is to dismantle its inherent architecture of selectivity, independence, and to reconstruct it as a plural and accountable system of governance in which the global South assumes not a derivative role, but a constitutive authority in defining the very ethics and institution of protection. Thank you.
Honorable Chief Justice of the Republic of Kenya, Martha Koome, Honorable Justice Nestor Kalubeba, Honorable Justice Isaac Lenaola, Honorable Justice Yuki Luku, ladies and gentlemen. From a European perspective, the field of migration is witnessing two challenging opposing movements. A more or less restrictive one, in particular in the field of asylum law, and one driven by the economic demand, focusing on talent and labor migration. And the line between asylum and migration is blurred. In my presentation, I will focus on the field of asylum law and the European Union approach to deal with the challenges as a union of 27 member states. From an EU point of view, I see two major challenges facing the asylum system. Firstly, with already hosting millions of refugees, we need to prevent uncontrolled, illegal migration of people into the EU, meaning to ensure by asylum law that only those who have grounds for international protection enter. Secondly, across the European Union, member states face various migratory situations and pressures. Nevertheless, we have to achieve solidarity among the member states. That, because they have united under the EU, all have to apply the same asylum law. First, I would like to present to you some data that shows the magnitude of the challenges facing the EU and Germany in particular. The European Union, plus Norway and Switzerland, has seen about 1 million applications for asylum annually in recent years. Despite a declining trend, Germany still received by far the most applications in the EU. 350,000 in 2023 and 251,000 in 2024. Additionally, there are pending cases. In Germany, at the Federal Office for Migration and Refugees, which is a German authority responsible for all asylum procedures, and at the administrative courts, which are responsible for asylum cases. In 2024, for example, there were about 150,000 pending asylum cases just at our courts in Germany. And all in all, about 3.4 million refugees are living in Germany right now. The recognition rates, which reflect the percentage of asylum applicants granted refugee status or subsidiary protection in the EU, have fluctuated around 40% concerning the first instance decision on the application. Recognition rates, of course, vary widely by citizenship. For instance, Syrian applicants had a recognition rate of 90% in 2024. It will be declining in 2025. While Bangladeshi applicants, for example, continue to have recognition rates of approximately 4%. But the recognition rates for citizens of the same country of origin varied substantially between different EU member states. In Germany, the last years, approximately 40% of the applicants were successful in terms of international protection. It amounts to 50% in Germany when the granting of national humanitarian protection is also taken in account. I will talk about that later. In addition, of course, there are successful lawsuits by those applicants that haven't been granted protection by the Federal Office in Germany. The recognition rates vary. In my state of North Rhine-Westphalia and the administrative courts of first instance, they were about 20% the last years. So let us take a rough look at the numbers in Germany again. 250,000 asylum applications last year. 50% successful, meaning 125,000. Adding a very rough estimate of another 15,000 for successful court cases, because only 60% of the applicants filed a lawsuit against the rejection, and about 20%, as I mentioned, of them are successful. Then 110,000 applications for asylum have been unsuccessful last year. Compared to that, last year, about 20,000 deportations to the home countries were successfully carried out in Germany, and 10,000 people have voluntarily returned to their countries of origin with financial support from Germany. You see, there's a large need for action, especially for action that avoids people coming in our country without grounds for international protection. Taking these data and many other reasons in mind, the EU finally has decided to reform its institutional frameworks to address the challenges for the asylum system. Or it is at least a new and, as you will see, complex attempt to do so. After years of intense negotiations, the European Parliament and the Member States agreed on the Pact on Migration and Asylum in May 24. It is a structural reform of the European Asylum and Migration Framework called Common European Asylum System, CAS, aiming to establish a migration management within the EU and to improve the solidarity mechanism between the member states. It is designed to reliably limit and organize migration in the EU as a whole, to standardize procedures in all EU member states, to permanently limit illegal migration, prevent secondary movements in the EU, and to establish an effective system of returns. So, in general, it is all about solidarity, about making processes faster and more efficient, and about guarding the integrity of the refugee system. The Pact on Migration and Asylum consists of 11 legislative acts. They finally came into effect in June 24. The EU member states have until June 26 to implement the new regulations before the legal acts become applicable. In Germany, the government just presented 2 legislative acts that implement the new system into national law, and there's a big debate about it. 10 out of the 11 legislative acts of the new EU framework are regulations. Only 1 is a directive. This means most of the rules are directly applicable in all member states, starting in June 2026. That ensures uniform application of EU law across all member states, leaving no or only very little room for national variation. Due to the prohibition under EU law to incorporate regulations into national law, the so-called repeat ban, there is no need to establish national legislation, but non-corresponding regulations in existing national laws must be deleted. The European Acts also see numerous regulations that must be fulfilled by the member states by law. Responsibilities must be determined, and finally, the work at the operational level is needed. Just last week, EU Directorate General for Migration and Home Affairs, Brunner, asked member states to speed up in implementing the pact and ensure that their national asylum, reception and migration systems are ready by June 2026. What is not new? The criteria according to which applicants can qualify for international protection in the EU. Although most of you will know, let me shortly repeat it to clarify what the core of asylum law is in the EU. International protection means refugee status or subsidiary protection status. So firstly, recognition as a refugee needs a well-founded fear of being persecuted for certain reasons. This is basically the 51 Geneva Convention. Secondly, in Europe, a person is eligible for subsidiary protection if substantial grounds have been shown for believing that that person, if returned to his or her country of origin, would face a real risk of suffering serious harm. Serious harm consists of the death penalty or execution, torture, or inhuman or degrading treatment or punishment, or a serious and individual threat to a civilian's life or person in situations of international or internal armed conflict. So this is a lot more than the protection being given to refugees. I would like to emphasize that in addition to granting international protection under EU law, member states may grant protection under national law. Germany does, for humanitarian reasons. For example, in cases of serious illnesses that cannot be treated properly or affordably in the country of origin. The new qualification regulation now clarifies that national humanitarian statuses are authorized by EU law, provided that they are granted only to persons who do not fall under the scope of the regulation. And let me mention at this point that in Germany, we even have a fundamental right to asylum guaranteed in our constitution. The substance of this constitutional right corresponds to the Geneva Convention refugee status, but it is a constitutional right. The new EU qualification regulation also brings about changes. It aims at increasing the convergence in recognition rates across member states. In order to secure uniform asylum decisions across the EU, the member state authorities now have to take into account a common analysis and guidance on the situation in the country of origin, provided at EU level by the European Union Agency for Asylum. As German administrative courts, we have used them for years because they are of high quality and simply very helpful. I can highly recommend the EUAA country of origin information to everybody, even outside the EU. You find them online. Other changes with the Pact on Migration and Asylum affect the content of the protection granted. This aspect is actually one main objective of the new regulation. Ensure that a common set of rights in terms of employment, social benefits, healthcare, education, integration is available for beneficiaries of international protection in all member states to prevent secondary movements. But not only beneficiaries of international protection have to be provided certain rights by EU law. The member states also have to ensure adequate standards of living for those arriving to the EU and seeking international protection. Asylum seekers, for example, will have access to the labor market no later than 6 months after the application is registered, and member states are encouraged to provide earlier access, in particular to applicants whose applications are likely to be well-founded. Member states will have to ensure access to language, civic education, or vocational training courses. What is really new under the Pact on Migration and Asylum is a mandatory asylum border procedure and a return procedure. I will come back to it in more detail later. To maintain open borders in the EU as a cornerstone of the European idea and to make them future-proof, the EU's external borders must be reliably controlled. All individuals who enter the EU regularly now are to undergo an efficient and mandatory screening within a few days. This means uniform health, identity and security checks of migrants who cross the EU external borders illegally. And the collected data will find its way into an improved Eurodac database. The type of data registered in this database will expand. Not only fingerprints anymore, but also, for example, facial image or identity data. As I mentioned, a new development compared to the previous system is the introduction of a much criticized mandatory asylum border procedure and a return procedure in all member states. It enables particularly fast asylum procedures, which are guaranteed, for those individuals to whom granting protection is unlikely, so not for everybody. There are 3 cases stated in the asylum procedure regulation. The applicant intentionally misled the authorities or intentionally destroyed or disposed of an identity or travel document. The applicant is a danger to the national security, or the applicant is of a nationality of a third country for which the proportion of decisions granting international protection is low, 20% or lower. While the application is being examined, applicants are allowed to stay at the border. The authorities' decision period is 3 months maximum. Of course, also applicants at the border are to be protected in accordance with international law, the EU Charter of Fundamental Rights, and in full respect of the non-refoulement principle. There are also significant changes asylum seekers will benefit from, not only the reception conditions I mentioned earlier, such as the mandatory provision of free legal advice. The procedural guarantees that safeguard the rights of applicants include free legal counseling during the administrative stage of the procedure. For example, information on the rights and obligations, assistance for lodging an application, information on how to challenge the rejection decision. And also there has to be free legal assistance and representation during the appeal stage upon the request of the applicant. With the new Pact on Migration and Asylum comes another attempt to guarantee more solidarity among EU countries in carrying out the asylum procedure. You probably have heard of the Dublin regulation, which basically stated that the member state where the applicant first files the application is responsible for carrying out the asylum procedure under the substantive law of this state only. This system did not work because it did not prevent effectively secondary migration. For example, from Hungary or Italy to Germany. We had many so-called Dublin cases at my court because the applicants may bring an action against the decision that Germany is not responsible. So we had to decide about responsibilities instead of deciding on international protection. And in the end, most of the applicants stayed in Germany anyway. We only have about 400 transfers annually from Germany to other EU member states. The Asylum and Migration Management Regulation aims to improve the system. It introduces the obligation to apply for protection in the member state of first entry. Additionally, EU countries will have a choice to support other EU countries facing migratory pressure, either by taking and processing some of the migrants, by offering financial contributions, or by providing operational and technical support when needed. Just last week, the EU Commission launched the first so-called annual migration management cycle under the new regulation. They determined the member states' level of migratory pressure. For example, Greece, Cyprus, Spain and Italy are under migratory pressure, which means that they will be eligible to access the so-called solidarity pool. Member states have to contribute to it according to their fair share, but they are free to choose the form of their solidarity contributions. And last, one idea of making asylum procedures faster and more effective is the concept of time limits and deadlines. They mainly concern the administrative procedure, but there will be decisional timeframes for the judiciary as well. EU law guarantees the right to an effective remedy against rejections of applications to everybody. The Asylum Procedure Regulation obliges member states to lay down in their national law reasonable time limits for the court or tribunal to examine decisions. In Germany, the law draft proposes that the court shall decide within 6 months of the filing of the claim. There are shorter deadlines for certain cases, especially in those of urgent actions. For us, as administrative judges in Germany, this is new. Usually we do not have time frames for our decisions. Will the new system be effective to cope with the challenges? That remains to be seen. For sure, the administrative court practice at our courts will be significantly affected by the EU reform and the planned adjustments in national law. On the one hand, the new regulations are highly complex, not least because of the interplay between directly applicable union law and national adaptation legislation. They will raise numerous legal questions that will require significant resources and time to resolve. On the other hand, the new regulations are intended to ensure that asylum proceedings are concluded quickly, particularly by setting deadlines for court decisions. The desired acceleration of judicial asylum procedures is hard to achieve by taking into account the complexity of the matter and the right to a fair trial guaranteed under EU law. Whether the tasks can be managed by the administrative courts in my country ultimately depends on the staffing levels of the courts. In my state of North Rhine-Westphalia, we are fortunate to have recently been allocated a substantial number of new judges to process the asylum cases. 15 next year at the first instance courts and 3 at my court, the Court of Appeal. Thank you very much.
Oh, thank you so much, Judge Dami, for that presentation. Ladies and gentlemen, an applause for my panelists up here. I'm sure that you will all agree with me that this is a fitting start to the conference and that we have just heard from some leading global experts in the field of refugee issues and asylum challenges. As I stood here listening, I recalled my days a long time ago when I was a protection officer in UNHCR many, many years ago, and the challenges still remain today. Ladies and gentlemen, as I said earlier, there is no time for us to interact with the presentations at this time. What I will ask, and this is the proposal from the Bureau organizing the conference, is that the question and answer session will move to take place after session 2, so that we shall have a joint question and answer session of session 1 and session 2. Once again, let me thank the panelists for their presentations and ask them to take their seats. Thank you very, very much. The Honorable Chief Justice, Martha Women, the Honorable Chairperson of this conference, my brother Isaac Lenaula. I now would like to hand over the next steps of the conference to Rose Washoka, so that she will guide us as to what we need to do at this time before the opening ceremony. I thank you.
Thank you very much, my Lady Justice Njokindomo, and thank you to all of you. Honorable Chief Justice, distinguished delegates, I now invite your attention to a special message by the United Nations High Commissioner for Refugees, His Excellency Filippo Grandi, and thereafter I will tell you the next steps. team is working on the sound, allow me to invite your indulgence. After the special message, we will take a tea break and we'll be back in the hall at 10:20 in time for the opening ceremony. Our protocol colleagues will notify us. There will be a bell to help us be ushered in after the tea break. If we have sound, we can take the special message.
Play a influential role in upholding the global tradition of asylum and sanctuary. Their decisions and actions can transform lives, helping offer protection, restoring dignity, and reaffirming the humanity of those fleeing war, violence, oppression, and abuses. This is why UNHCR is proud to have supported the International Association of Refugee and Migration Judges since its founding in 1995. Your efforts in helping judges and working with states to exchange knowledge, practices, and jurisprudence are vital to the development of refugee law and the protection of those in need. Yet today, this very regime is under increasing pressure. Across many countries and headlines, we see the politicization of asylum issues and the principles of protections questioned. In the face of complex population movements and overwhelmed asylum systems, we must remember the international refugee protection regime has saved millions of lives. It has offered safety and upheld rights. While concerns about migration management are valid, there are concrete ways to address them while ensuring protection and solutions to those in need. Ways that respect national imperatives while reinforcing, not undermining, international law. UNHCR will continue working with states all around the world to pursue these solutions, and we count on your continued support. Together, we can ensure that protection remains a reality and not just a principle. I thank the Association for its enduring partnership and commitment, and I wish you all a productive and enriching conference.
That profound message. Another round of applause. I think we've had a very, very successful first session, and when we come back, we will adjust the small technical hitches we're having so the proceedings should move smoothly. Let me now welcome you to a tea break. We will reassemble at 10:20 or when we hear the bell.